Yes.
Right? Here's another team of lawyers in the provincial government going, yeah, no, there's no way that the CCFR should have lost in this. You know, we've said all along, like the other things, we went in on self-defense, we went in on other charter challenges. But the one thing that we shouldn't have lost on at all was the administrative law portion. And there's a lot of people agreeing with that. So just it's very interesting that the Judge Kane ruled against us in the first place.
Are Rod and Tracy right? And what if I told you I can prove that the Canadian assault-style firearms ban was against the law? Let's have a look. Welcome back to the channel. So today we're going to be finishing our CCFR versus Canada series. Up until now in the series, we've covered only a fraction of the individual flaws I felt were present in Justice Kane's ruling. However, those arguments were all presented on the premise that the government actually had the authority to ban these firearms in the first place. And what if I told you that that actually isn't the case? That the government has no such regulatory authority to blanket ban our firearms in the way that they did. If you've been watching this series up until now with the idea that I've been making some pretty good points, all of them pale in comparison to this one. If you watched my earlier video discussing the unconstitutionality of the C-21 handgun freeze, this is the slam dunk I referred to. In this video, I'm going to demonstrate beyond any doubt that the CCFR was right in saying that the government acted beyond its lawful authority to create these regulations under Section 117.15 of the Criminal Code. And therefore, their actions were ultra vires. Ultra vires meaning that it was beyond their lawful authority to ban the firearms in the way that they did, and as such, the entire OIC could be rendered null and void, although there are lesser options than that. I will also explain the errors Justice Kane made, which allowed her to come to the wrong conclusion. Whether or not you think these errors rise to the level of prejudice or bias is up to you, but whether these errors were made deliberately or not does not excuse the fact that Justice Kane was wrong to rule the way she did on this particular point. But before we go any further, it's critically important that you understand exactly what Section 117.15 of the Criminal Code says. And it can be broken down into two distinct parts. So first up, we have subsection 1, and it says, subject to subsection 2, the Governor and Council may make regulations prescribing anything that by this part is to be or may be prescribed. And this section gives the government the authority to change the classifications of firearms. In actuality, it gives them a whole lot more powers than just that, but for the purposes of this OIC itself, they only use the power to prescribe firearms as prohibited, as well as the powers to prescribe AR-15, AR-10, M4, and M16 uppers to be prohibited devices. So that means the upper receiver of an AR is basically also a prohibited device, in addition to the fact that the lower is also banned because that has the serial number. And subsection 2 of the OIC powers state that it's a restriction. In making regulations, the Governor and Council may not prescribe anything to be a prohibited firearm or a prohibited device if, in the opinion of the Governor and Council, the thing to be prescribed is reasonable for use in Canada for hunting or sporting purposes. So in effect, the power can be broken down into two rules. Rule number 1 lets you ban things through an order in council, and rule number 2 says that you can't ban things if, in the opinion of the Governor and Council, those things are reasonable for use in Canada for hunting or sporting purposes. And this is going to be extremely important in a few minutes here, so rewatch this section if you didn't quite get that or you're not on board or you're still misunderstanding something. Rule number 1 says the government can ban things, and rule number 2 says there are some things which you cannot ban. And these two rules work together simultaneously to specify exactly how much authority the Governor and Council has to actually ban things. But now that we have that sorted, we need to again mention the standard of review in this case. And that's the Reasonableness Standard as established in the Supreme Court case of Vavilov. I've discussed it many times by now throughout the series, but Justice Kane's job in reviewing the order in council wasn't to find out whether or not the government was correct in deciding to ban our firearms. It's also not her job to show that there was a better or fairer way to accomplish the government's proposed goal of public safety. It's also not her job to say that she would have done something differently. All she's concerned with, or at least all she's supposed to be concerned with, is if the government acted upon a reasonable interpretation of the powers given to them by Section 117.15 of the Criminal Code. A full breakdown of reasonableness would take far too long, but paragraph 68 of the Supreme Court precedent in Vavilov sums up the rules rather nicely for us. And it says, reasonableness review does not give administrative decision makers free rein in interpreting their enabling statutes. and therefore it does not give them license to enlarge their powers beyond what the legislature intended. Instead, it confirms that the governing statutory scheme will always operate as a constraint on administrative decision makers and as a limit on their authority. Even where the reasonableness standard is applied in reviewing a decision maker's interpretation of its authority, precise or narrow statutory language will necessarily limit the number of reasonable interpretations open to the decision maker, perhaps even limiting it to one. Conversely, where the legislature has afforded a decision maker broad powers in general terms, and has provided no right of appeal to a court, the legislature's intention that the decision maker have greater leeway interpreting its enabling statutes should be given effect. The Vavilov precedent here says that the government cannot enlarge their powers beyond what the legislature intended. And so essentially, the purpose of a reasonableness review, at least for the context of this video, will be to determine if the regulations promulgated by the Order in Council align with Parliament's intent behind the grant of authority found within Section 117.15 of the Criminal Code. So what did Justice Kane determine was a reasonable interpretation of this statute? Well, the back and forth between the CCFR and the Attorney General of Canada went something like this. The CCFR and friends all stated that the reasonable interpretation of 117.15 was that subsection 2 should protect firearms which are reasonable for use in hunting and sport, and that the government should have to explain why such firearms are not reasonable for use in hunting and sport before they are banned. And the Attorney General said that assault-style firearms are not reasonable for hunting or sport because they are inherently dangerous, claiming issues regarding public safety. The government also justified their ban by saying it's okay to ban these firearms because there's not very many of them and there are other firearms which can be used for hunting or sport. And the CCFR correctly reminded Justice Kane that necessity is not the threshold. Just because there are other firearms doesn't make certain firearms less reasonable for sport. That's not a valid justification of the powers in Section 117.15 of the Criminal Code. The CCFR and friends also correctly stated that inherently dangerous is an insufficient threshold for determining unreasonableness, since even the remaining firearms which are reasonable for use are inherently dangerous. All firearms are inherently dangerous. So if inherently dangerous is the threshold, then subsection 2 doesn't actually do anything. It offers no actual limit on the government's authority. And even the province of Alberta, who was largely absent through most of the issues and disputes in this review, even they got in on this action. After considering all of these arguments, what did Injustice Kane end up ruling? Well, in a surprise to absolutely no one at this point, she sided with the government. Because of course she did. Now what is rather surprising though, is how exactly she ended up doing it. Because I gotta be honest here, this lady be cray-cray. Like, you don't have to be a lawyer to see the myriad of ways she just goes off the rails here. Not the least of which is how she completely disregards what the law actually says. For example, in paragraph 309 of her ruling, she says, quote, subsection 117.15 subsection 2 of the Criminal Code gives the Governor and Council the authority to prescribe firearms as prohibited, end quote.
But hear this. Fuck that shit.
Now, if you remember when I explained the OIC powers to you, subsection 1 says you can ban things, and subsection 2 says there are some things you cannot ban. Even if you can test the specifics of what a reasonable interpretation of subsection 2 can bear, it's very clear that there is no power to ban anything in subsection 2. It offers no powers to prescribe. It exists solely as a restriction on subsection 1. And this error isn't a one-off or a typo of any kind either. In paragraph 306 she said, quote, as noted below, Parliament intentionally enacted 117.15 subsection 2 to delegate to the Governor and Council the authority to prescribe additional firearms as prohibited, end quote. For those who may not understand, this is not a small error. Like, this isn't some tiny technicality I'm making a fuss over. This is actually a pretty big deal. Injustice Kane is responsible for determining whether an interpretation of the statute is reasonable. And the powers given by subsections 1 and 2 are radically different in the eyes of the law. Yet we see her outright declaring a manufactured definition which literally doesn't exist at all in the statute. Now, as I always say, I am no lawyer. What could I possibly know? Like, she's a federal judge, for crying out loud. I'm just some dude who hates reading slightly less than he hates what the government is doing to him. Surely her expertise is greater than mine, right? Well, in paragraph 324, she seals her fate. She says, quote, the Order in Council specifically refers to subsections 84 and 117.15 of the Criminal Code as the underlying authority to make regulations. And here's the thing. The Order in Council absolutely does not say that. Not even remotely. and we can even pull up the order in council to confirm it. Both at the very top of the order and as well as in the Reas, the power used to ban these firearms is very clearly the combination of 84 subsection 1 and 117.15 subsection 1. Again, this is not a small mistake to be making. She's stating that the government has powers that they do not actually have, and then she is making an assessment of reasonableness on that flawed criteria. And it's difficult for me to envision how this is some kind of accident. Like, this didn't just happen once, but over and over in her ruling. And not only that, it's not like she was misled by the Attorney General either, not that that would be any excuse, because in paragraph 268, the Attorney General also clearly states the law correctly. 117.15 allows firearms to be banned, subject to subsection 2. So I completely agree that her expertise is greater than mine. But even I know this interpretation of the statute is just not factually or legally accurate, let alone reasonable. So how can a federal judge accidentally miss the mark by this much? I don't know, honestly. I don't know. Hence my insistence on some kind of underlying bias or prejudice throughout the entire series to explain it all. And this is far from the only mistake she makes in regards to this section of her ruling. But it does lead to a sort of snowballing effect. Now that she has incorrectly established that Cabinet has the authority to prescribe firearms as prohibited under subsection 2, based on the reasonableness for use in hunting or sport, it opens her up to be able to side with the government's story. Which, if you're a cynic, you might think that's why she got it wrong in the first place. From here, she begins substantiating the government's claims regarding the OIC. In paragraph 301, she says, "The court finds that the language chosen by Parliament to describe the Governor and Council's authority in 117.15.2 of the Criminal Code is broad and highly qualitative, which signals that the Governor and Council has greater flexibility in interpreting its meaning. The language conveys that in order to prescribe a firearm as prohibited pursuant to subsection 84.1, the Governor and Council must form the opinion that the firearm is not reasonable to use in Canada for hunting or sporting purposes. If this language is not highly qualitative, it's certainly qualitative. In this case, although the applicants argue that a very narrow interpretation should apply, the grant of authority is not narrowly drafted. The question is whether the Governor and Council has justified its interpretation of its grant of authority, and the court finds that it has." Injustice Kane then goes on to substantiate the government's claim that the threshold for not reasonable is anything which is inherently dangerous or a threat to public safety. In paragraph 336, she says, "There are two sides to every coin. The Reas does not focus on identifying firearms that are reasonable for hunting or sport, but rather those firearms that are not. The Reas focuses on the characteristics of a firearm that make them not reasonable for use by civilians for hunting or sport, not the characteristics that firearm owners regard as making firearms more effective from their own perspectives. The Reas clearly explains the emphasis on public safety and the inherent dangers of the prescribed firearms due to their characteristics and capacity to inflict severe harm, which supports the Governor and Council's conclusion that the firearms are not reasonable for use in hunting or sport. However, the requirement set out in 117.15 subsection 2 expressly requires you to identify firearms reasonable to be used in sport, not firearms which are dangerous. Subsection 2 is labeled as a restriction on the powers laid out in subsection 1. It must be viewed in the context of a limitation on its powers to use 117.15, not as a generalized power or an enhancement as the government and the courts interpret it as. And this was correctly argued by nearly all of the applicants in our case, the CCFR included. So how do we prove that she and the government are wrong? How can the CCFR avoid their appeal falling on deaf ears when they bring this up at the Federal Court of Appeals in December here? How can we demonstrate beyond any doubt that subsection 2 is to be interpreted narrowly and only as it says, rather than it being considered as broad or highly qualitative language? And here's where I think the CCFR, as well as other applicants so far as I can tell, actually make a small tactical mistake in their argument. Now to be fair here, I have the benefit of hindsight. There is no good reason that their argument shouldn't have worked the first time around. They were and are in the right, and I don't know that I would have come up with this argument except that I was able to see how and where Injustice Kane went wrong after the fact. In paragraph 232, the CCFR had this to say. The CCFR applicants argued that subsection 117.15.2 conveys that not all firearms can be prescribed, only those that in the opinion of the Governor and Council are not reasonable for hunting and sport. These constraints on the Governor and Council's authority pursuant to subsection 117.15.2 cannot be rewritten. The Governor and Council must form the opinion, and its opinion must be reasonable. They submit that the Attorney General's focus on public safety is not a relevant consideration. If the Governor and Council were authorized to prescribe firearms as prohibited for public safety reasons, subsection 117.15.2 would have been drafted accordingly. Moreover, if the Governor and Council could base its opinion on public safety considerations, it could prohibit all firearms, which is contrary to the statutory constraint. And that is an excellent argument. That is completely correct, and it should have won the case. That is the reasonable way to interpret the statute, as well as consistent with the intended purpose of the statute. The statute does not actually use broad or qualitative language, and it limits the number of reasonable interpretations open to the decision maker down to one. However, that argument is not articulated very well, and it encounters the very same flaw that Injustice Kane did when she sought to interpret its meaning. And as useful as it is to assert your own view, it's more effective to show why the government is wrong. After all, in a reasonableness review, the government is owed deference. A mere difference of opinion is insufficient. You must show that the government's actions or interpretations were unreasonable, not necessarily just that your interpretation is better. So if the CCFR instead explains it like the way I'm about to when they get to the Federal Court of Appeals, I don't see how we can lose. So I think the problem that everyone fell victim to in determining the purpose of section 117.15 of the Criminal Code is that all parties got tunnel vision on the criteria set out in subsection 2. Everyone got bogged down in defining what reasonable for hunting or sport could mean, but that grant of authority and whatever meaning and power it ought to carry doesn't exist in a vacuum. It has to be seen in the context of subsection 1. So in order to demonstrate that the restriction on power ought to be very narrowly interpreted, and to further prove just how badly Injustice Kane screwed up, consider this. What if subsection 2 simply didn't exist at all? What if 117.15 only had one part, and that part simply said that the Governor and Council has the ability to prescribe firearms as prohibited? What kind of powers would that statute alone offer the Governor and Council? What would an order in council born from that clause alone actually look like? Well, the government would probably not need any real reasons or justifications, but they would still be required to fill out a regulatory impact analysis statement, since most order in councils are required to have one. So what justification would they give to ban our firearms? Well, public safety, of course. Such is the nature of all gun control regulations according to Injustice Kane. They would then prescribe any firearm they deem too dangerous for civilian use, and they would likely declare specific reasons for banning the firearms that they wanted, claiming that they have certain features or characteristics which make them too dangerous for civilians to have. Of course, we would object, saying that we use many of these firearms for various hunting, collecting, self-defense, sporting, whatever, the normal shtick. But the government would simply say that none of this trumps their public safety concerns. Does any of this starting to sound familiar yet? It should. That's actually exactly what the Order in Council says. Everything the government did was solely the result of the powers laid out in subsection 1. And the order very clearly says that they used the powers laid out in subsection 1 to make the regulations in banning our firearms. The OIC actually makes no mention at all about using any powers found in subsection 2. And this is because there are no powers to be found in subsection 2. The government merely grafted the wording from subsection 2 to imply that they had considered its restrictions, but their interpretation of its definition means that there was no restriction. Whether or not subsection 2 was there, the government would have banned our firearms in exactly the same way that they did. The government would have banned our hunting and sporting firearms on the premise that they were a public safety concern and that these firearms were unreasonable for safe civilian use. So my question is this: if banning firearms for the sake of public safety is clearly in the domain of subsection 1, how can it also be held to be the domain of subsection 2? And the answer is that it can't be. It's not reasonable to presume that the intended purpose of the restriction laid out in subsection 2 is somehow to enable the government to ban firearms in the name of public safety. First off, subsection 2 is clearly labeled as a restriction, and restrictions don't enable. That's just a ridiculous and ironic idea in and of itself. But secondly, public safety considerations are clearly enabled by the powers granted in section 1. As a part of Injustice Kane's ruling, another Supreme Court case was brought up. And I've talked about this one before on the channel, but this case was about determining the purpose and constitutional legitimacy of the Firearms Act and other related amendments of 1995. Our intervener, Alberta, said it was about the legitimate use of firearms in the context of public safety. And the Attorney General specifically quoted paragraphs 20, saying that the bill was about public safety. And of course, in a surprise to absolutely no one, Justice Kane completely disregarded the information brought forth by Alberta in order to cherry-pick the information from the Attorney General. Let's take a look at the paragraph that Injustice Kane conveniently decided she wasn't going to look at. So in paragraph 20, It explains the intended purpose of the Firearms Act. First, tough measures to deal with the criminal misuse of firearms. Second, specific penalties to punish those who would smuggle illegal firearms. And third, measures overall to provide a context in which the legitimate use of firearms can be carried on in a manner consistent with public safety. So, despite what Injustice Kane willfully omitted from her ruling, it's clear that the Supreme Court precedent agrees that creating a space for the legitimate use of firearms was as much the intention of then Bill C-68 as it was about public safety. Clearly, the intent was about balancing the two, which is, again, something that the applicant stated repeatedly throughout the case. And no doubt the powers in subsection 1 to prescribe firearms as prohibited were instituted with the idea of public safety in mind. However, subsection 2 is clearly about the balance and creating space for the legitimate use of firearms. Otherwise, there would be no point for it to exist. It's not reasonable to presume that subsection 1 is about banning firearms for public safety, and that subsection 2 is somehow also about banning firearms for public safety. That would make subsection 2 redundant. And it's also not reasonable to presume that Parliament didn't consider the possibility of firearms use in mass shootings, since the Firearms Act and the Criminal Code amendments in 1995 were largely the result of the MCI at École Polytechnique in Montreal. And while that wasn't their only concern, it is clear that that was the catalyst which drove them into action. The dangers posed by firearms in the light of a possible threat to public safety would have been at the very forefront of their intentions when drafting this legislation. MCIs would no doubt have been at the epicenter of such concerns regarding the dangerous misuse of firearms. Even having considered that, Parliament still opted to place restrictions on the reasons for which firearms may be banned under Section 117.15. It is not enough to simply stipulate that a firearm is inherently dangerous or that it can be used to hurt people. That would again be covered under subsection 1. If public safety was truly the exclusive intent of the authority granted to Cabinet for the purposes of banning firearms under Section 117.15, then they never would have bothered to make it subject to any restrictions in the first place. And they could have repealed the existing section if they wanted to, but they intentionally left such restrictions in. Not only that, but if you side with Injustice Kane and the government in believing that both Section 1 and 2 were enacted to enable the government to ban firearms for public safety reasons, it no longer makes sense when you read it aloud. The section would effectively say that as long as you ban firearms for public safety reasons, then you can ban firearms for public safety reasons. Not only does that not make any sense on its own, but then one must also ask the question, what restriction would subsection 2 actually offer on subsection 1's powers if that were the case? The statute clearly states that subsection 2 is supposed to restrict something, but if both sections are about banning firearms for public safety, then what does it actually restrict? After all, firearms are inherently dangerous and all parties agreed to this in Kane's ruling. So if any firearm can be banned for public safety reasons under subsection 2, as it can be banned under subsection 1, then subsection 2 offers no restriction to subsection 1's powers. So that interpretation really doesn't make any sense. However, if you consider in the manner that the CCFR and other applicants see it, that it clearly says that so long as you don't ban firearms which are reasonable for hunting or sporting purposes, then you may ban firearms for public safety reasons. Which, by the way, is what the actual letter of the law says and doesn't require any reinterpretation or rewording. And it also makes it very clear what possible restriction the legislature had in mind when writing the statute. And it also makes the restriction meaningful and effective. And Vavilov's reasonableness precedent would also agree with this interpretation of the statute. In paragraph 121 of Vavilov, the Supreme Court had this to say: "The administrative decision-maker's task is to interpret the contested provision in a manner that is consistent with the text, context, and purpose, applying its particular insight to the statutory scheme at issue. It cannot adopt an interpretation it knows to be inferior, albeit plausible, merely because the interpretation in question appears to be available and is expedient. The decision-maker's responsibility is to discern meaning and legislative intent, not to reverse engineer a desired outcome." So just because the government and Injustice Kane want to believe that reasonable for hunting or sporting purposes can also be conveniently reinterpreted to mean unreasonable for public safety reasons, that interpretation is insufficient according to Vavilov. And this is what the CCFR and Alberta were arguing when they said that public safety is an irrelevant consideration in regards to subsection 2. However, they incorrectly asserted that if the government had intended for subsection 2 to enable public safety considerations, they simply would have included that in the wording of subsection 2. But in reality, it would be more accurate to say that they never would have included a subsection 2 at all if public safety was truly their only objective. It would be redundant to write two statutes giving the government one identical parameter of authority. So when Injustice Kane ruled that the Order in Council and regulations are not ultra vires, and that the Governor in Council did not exceed the statutory grant of authority delegated to it by Parliament pursuant to subsection 117.15.2 of the Criminal Code, what she actually ruled, in effect, was that subsection 117.15.2 of the Criminal Code simply doesn't exist. Which brings us back to the reasonable interpretation of the statute. So if subsection 2 isn't about banning firearms for public safety, then what is it about? Now that such a perverted interpretation is demonstrably invalid, there is only one reasonable interpretation which remains, and it must be held to restrict the government's ability to ban firearms, which is very clearly what it says in the first place. It exists as a protection for lawful firearms owners to reasonably engage in legitimate hunting and sport shooting. And the normal issue that public safety is automatically more important than lawful firearm ownership is actually not true in the use of these specific powers. And this may well be the only place in Canadian law where such a thing is true, but it is true. And this is because, as we've established, subsection 1 pertains to public safety, and subsection 2 pertains to hunting and sport shooting. And this statute very clearly says that subsection 1 is subject to subsection 2. Period. Full stop, end of story. And as such, there can be no reasonable interpretation of the statute which permits concerns over public safety to trump our protections for hunting and sport shooting. And therefore, the CCFR and friends were and are entirely correct. The definition of reasonable must be viewed narrowly and only as it relates directly to a firearm's benefit for hunting and sport shooting. But what is reasonable? Defining what this threshold is was discussed in a few different ways during the case by various applicants, but for me, it should be required for the government to show that a firearm can only be unreasonable if it provides some detriment in direct relation to its use or capabilities for hunting or sport shooting. And for example, armor-piercing ammunition would be unreasonable for hunting or sporting purposes. Such ammunition has already been banned in Canada for a long time, so it's a bit of a moot point, but they make a good demonstration for what detrimental is. AP rounds are less effective against animals since they do not expand on impact the way most normal hunting rounds are designed to, and this results in less ethical shooting as well as concerns regarding overpenetration. AP rounds are also a bad idea for use at ranges in sport shooting. They can damage metal targets and pierce backstops at indoor ranges. AP rounds are also more prone to ricochets since they resist losing their energy by not becoming deformed or destroyed on impact. And all of this means that AP rounds create exclusively detrimental problems with no positive benefit or return for people engaging in hunting or sporting, and as such are not reasonable for hunting or sporting purposes. Now, to be clear, I'm not saying that I think AP rounds should be prohibited, but if the legal threshold is reasonable for use in hunting or sporting, then AP rounds would be found to be unreasonable for such purposes, and therefore could be lawfully banned under the powers of 117.15. Now, there is one word remaining that I've been glossing over this whole time. Opinion. At the end of the day, the statute states that what is reasonable and what is not comes down to the opinion of the Governor and Council. Despite all that I've said here today, if the Governor and Council opts to take a different opinion of things, would that be enough to save the government's interpretation of their powers? Could the Governor and Council really hold an opinion even if that opinion is entirely unreasonable or even outright wrong? Even if that opinion is not consistent with the intended purpose of the statutes? And fortunately, no. Vavilov tells us this. There is no such thing as absolute and untrammeled discretion, and any exercise of discretion must accord with the principles for which it was given. Likewise, a decision must comport with any more specific constraints imposed by the governing legislative scheme, such as the statutory definitions, principles, or formulas that prescribe the exercise of a discretion. So if we take my proposed definition of unreasonableness to be interpreted as detrimental, then the Governor and Council would be required to show that he has the opinion that any such items outlined in subsection 2 are detrimental as it relates directly to their use for hunting and sporting purposes. While what the Governor and Council may consider to be a detriment could potentially be given some wider deference, it wouldn't be reasonable to have his opinion extend beyond the narrow and single reasonable interpretation that we established. For example, the Order in Council bans grenade launchers and missile launchers and so on. Not that these things were legal for PAL holders before the Order in Council anyway. However, if you were to measure their reasonableness for hunting, there is no doubt that such armaments could kill a deer. But it could still be opined by the Governor and Council that these items are detrimental to hunters because it could damage the meat beyond a harvestable state, or it could result in instances of a hunter harvesting more game than his or her allotted tags. However, It would not be a reasonable opinion to say that any particular so-called assault-style firearm is not reasonable for hunting simply because there are other firearms available, or even that there may be more appropriate firearms available. For example, just because a bolt-action civilian rifle is sufficient for hunting, that doesn't mean a semi-automatic assault-style rifle is somehow detrimental to hunting. Reasonability is not to be reinterpreted as unnecessary or suboptimal, even if it's the Governor and Council's opinion that such a thing is true. And this is a tenet of reasonability, which is consistent with the legal threshold of reasonableness as it relates to judicial review. In a sense, we can adopt the court's idea of reasonableness to create a workable definition for what the word reasonable means within this statute. If it is not reasonable for the courts to determine the correct or optimal course of action for the government, then it is also not within the idea of reasonableness for the Governor and Council to be determining which firearms are correct or optimal for our uses as they relate to hunting or sporting purposes. The Governor and Council must consider all firearms which fall within a range of appropriate options to be reasonable. To do otherwise would not only contradict the court's own definition of reasonableness, but it would also invalidate the established intended purpose of the provision, which is again to protect the legitimate use of firearms for lawful hunting and sporting purposes. Funnily enough, this is even something that Injustice Kane understands and agrees with. But of course, she doesn't have the stones to just say that the Attorney General was wrong. She says that it's not the test, but also that it is somehow a factor. And no, it's not. If it's not within the limits of the statutory language, then it's wholly irrelevant. So, if the CCFR takes this argument to court, I don't see how any reasonable judge can shoot it down. The government is to be afforded deference in a reasonableness review, but that deference is not limitless, and it must be gauged in accordance with the intended purpose of the statute. Not only is it plenty obvious on its own, but I've also made it very clear what the intended purpose of the statute is, as well as the statutory limitations. And it's equally clear that the government did not act in accordance with that intent, nor did it respect the statutory limits set on its authority. And as such, the regulations in the Order in Council are ultra vires. When the CCFR goes to court, we should win, and we should get our scary black rifles back. Unless, of course, the Federal Court of Appeals is as biased as Injustice Kane was, then who knows. But like I say, the CCFR and friends already said most of these things and made most of these arguments, but I think they need to be mindful of how they phrase it to the Federal Court of Appeals so as to ensure that the court has not even an illegitimate excuse for ruling against us. All this being said, none of what I've said here today means the government will never be able to mass ban our hunting or sporting firearms again. It just means that they won't be able to use the Order and Council powers to do it. The government can and still will have the authority to do it through enacting new legislation and having that legislation receive royal assent. For example, the handgun freeze is enshrined in legislation. It cannot be overturned by an ultra vires ruling through analysed in section 117.15 because they use Parliament's legislative powers to freeze them. Now, I'm not saying that there isn't anything we can get the courts to do about it, and I even made a video bringing the constitutionality of the handgun freeze into question. What I'm actually saying is that going forward, we should not have to worry about our community being criminalized and our culture being destroyed overnight merely by the stroke of an intolerant pen. And wouldn't that be something to behold?